Now, ladies and gentlemen, we've kicked off this afternoon with the act of handing over a book to our friend Arthur Hartkamp, and we do not want to conclude this evening without handing over another book, yet another book, to Arthur Hartkamp. And it is not, I may say, the eagerly expected case book, of which I can hand over the first volume, because Arthur, I'm afraid you have been deceived. You have been deceived by Carla Sieburgh, because in your program for this afternoon, my modest contribution has been listed under a fake title. I'm not actually going to talk about national law and European private law. Okay. I'm talking about something else. I'm talking about you and about the book that I'm going to hand over to you. I have present here a special issue of the European Review of Private Law, which will officially appear on Monday. And in effect, it constitutes a Festschrift in honor of our friend and colleague Arthur Hartkamp. There are 19 essays contained in this book, and they all relate to topics that have been and continue to be of central interest for Arthur. European private law, the national private laws in Europe, the interaction between these bodies of law and the emergence of a European private law, drawing its inspiration inter alia from that interaction. The legal developments analyzed in these essays are all of considerable interest, both, we hope, to Arthur and to the wider community of private lawyers. And this is why we chose to slot them into the ongoing debate in a journal specifically dedicated to European private law through the kind cooperation of Ewout Hondius, rather than to produce a freestanding book that may all too easily be overlooked or forgotten. Arthur Hartkamp, born in 1945, began, as did Ernst Rabel, his career as a researcher in Roman law at the University of Amsterdam. His thesis, entitled Der Zwang im römischen Privatrecht, was published in 1971. Together with a number of essays published in subsequent years, it earned him the reputation of an outstanding legal historian. We've heard a new Ulpian. In 1974, however, he became a member of the Civil Code Revision Office in the Dutch Ministry of Justice. And I want the light-seeking youth that is sitting here to note this point. As a Roman lawyer, you are able, with a thorough grounding of Roman law, you are able to do anything. You can become the draftsman for the civil code in the Netherlands, for example. Because in that capacity, Arthur was hardly involved in the drafting of those parts of the new Dutch civil code that entered into force in 1992. At the same time, Arthur continued to be interested in legal history and increasingly also in comparative law, and he brought these perspectives to bear upon his work within the Civil Code Revision Office and upon his publications. For new insights, Arthur was able to rely also on his involvement in various international projects. Thus, he was the Dutch delegate to the United Nations Commission on International Trade Law, UNCITRAL, and a member of several of its working groups. He was the head of the Dutch delegation to the Diplomatic Conference on the United Nations Convention on Contracts for the International Sale of Goods. From 1984 onwards, he he has been a member of the Governing Council of the International Institute for the Unification of Private Law, UNIDROIT, in Rome, and since 2003 he has been the vice president, or rather the first vice president of that body. Of particular significance for the internationalization of private law was also his membership in the UNIDROIT working group that produced the principles of international commercial contracts, 1994, revised editions 2004, 2010. Marcel Fontaine, who was also on that body, is here with us today. And of the Commission on European Contract Law, the Landau Group, responsible for the principles of European contract law, 2000 and 2003. In 1986, Arthur became an Advocate General and in 2001 Procureur General at the Supreme Court of the Netherlands. Apart from that, he served as a part-time professor of private law, first in Utrecht and subsequently in Amsterdam. Arthur's work is characterized by a unique combination of academic and practical skills and experiences, a supreme sensitivity for the specific circumstances of each case and for its context, legal and otherwise, goes hand in hand with an enviable ability to employ doctrinal reasoning in order to find solutions that are both elegant and reasonable. His distinguished contribution to legal scholarship was recognized by his election as a member of the Royal Netherlands Academy of Arts and Sciences in 1985 and of the Academia Europaea in 2013. Over the years, Arthur has continued to be a prolific author of books and legal articles. Most important among them for Dutch legal scholarship and legal practice are his authoritative 4 volumes in the Asse series on the Dutch law of obligations. Between 1984 and 2015, he published every 4 years a new, revised and updated edition of each of these volumes. In 2008, he added another, the 5th volume, on the impact of European law on Dutch patrimonial law, which is now in its 3rd edition. Internationally, Arthur is known inter alia for his publications drawing on the experiences of recodifying the Dutch law of obligations. Thus, for example, he espoused the value of open norms in a modern codification. In 1990, Arthur, together with a number of Dutch colleagues, launched a volume entitled, was mentioned already, Towards a European Civil Code, now in its 4th edition, 2011, which has been highly successful in stimulating a broadly based debate on the Europeanization of private law. Given his interest in the process of Europeanization and on the law in action, it was hardly surprising that Arthur's academic interest increasingly started to focus on the influence of European law on contemporary private law. In 2006, he resigned from his office as Procureur General at the Supreme Court and accepted a research chair in European private law created for him at this university, the Radboud University Nijmegen. Arthur thus moved back to full-time academic life and initiated a number of national and international research projects. In addition, he started to teach students of the research master program and young scholars of the Nijmegen Law Faculty, and he was invited to train Dutch judges in EU private law. As will become apparent from the essays collected in this volume, many colleagues have been inspired by Arthur's work. However, they have also been inspired by his erudition and his very wide range of interests. He has translated poetry from ancient Greek as well as from Italian. By the ease with which he is able to express himself in many different languages, and as we have learned today, dialects as well, by his kindness and his readiness to assist young colleagues. That is something which has particularly always impressed me, and by the contagious enthusiasm for discussing new and interesting legal problems and always accepting new challenges. With this volume, we would like to pay tribute to your enormous contribution to the development of private law in Europe, and at the same time, it is a token of our affection for you as a scholar, a colleague, and a friend. And this is the real title of my contribution, not what is written in the fake program there. It is Arthur Hartkamp, scholar, colleague, friend. And I think it is significant that just about every contribution to the volume here starts with personal recollections about his or her experiences in collaborating with Arthur. By way of example, I will just read the first few lines of one of the essays. Arthur Hartkamp est un collègue et ami que j'admire beaucoup. I think everybody in this room will agree with this. Pendant des années, nous avons participé ensemble au groupe de travail qui a élaboré les principes d'unidroit relatifs au contrat du commerce international. Arthur Hartkamp a été l'un des membres les plus écoutés du groupe, dont les avis et suggestions ont toujours été pertinents et souvent décisifs. Cet excellent juriste est également un homme de grande culture et enfin lettré, que j'ai parfois surpris. Dans les rares moments où les discussions diminuaient dans son intensité, à lire sous la table, dans leur version originale, des poèmes latins ou grecs. The volume has been planned so as to appear in the same year in which Arthur's two most recent research initiatives have come to fruition, the second revised edition of a work entitled European and National Private Law, Effect of EU Law and Human Rights, European Human Rights Law on Legal Relationships Between Individuals. You have seen this volume previously, and a new volume within the Jus Commune Casebook for the Common Law of Europe series entitled Cases, Materials and Sources on the Impact of Union Law on Horizontal Relationships, EU Law and Private Law. We sincerely hope that Arthur will continue to stimulate our thoughts through his publications as much as through discussing his views with us. Thank you, Arthur, for your friendship over all these years. So you hand this over.